There we go. Okay, hello everybody. Welcome to the 2024 Journal of Public Policy and Practice Fall Legislative Forum. My name is Melanie Aranda-Tawil. I am honored to be this year's policy editor, and this year we are presenting a topic that is incredibly important, especially today, as so many states are celebrating the very first day of early voting. There's no time like right now to actually be bringing up these really important topics, especially when we look at how far the pendulum has swung when it comes to civility and what we are willing to accept as a society, and how we as attorneys can move forward in our practice and also into our communities. As a reminder, this is a DEI credit of 1.5 if you are a Mitchell Hamlin student. Please make sure that you go to the DEI website. I will also be linking it here shortly to write your response. Please make sure you do it tonight because it's, no time like the present. Give yourself maybe 5 minutes to reflect on it. It's really short. But tonight we are presenting on, our big thing is on civility in today. And I wanted to bring this because we are all eventually going to be out in the workforce. We are all eventually going to be out there, and like it or not, we are already part of the workforce. It is up to us even now to be portraying that individual that we want to see out in the world. And so with that, we have two fantastic individuals who are going to be speaking. First is, oh my gosh, I'm really excited. I'm like in a really big fangirl here. And I met Christina very shortly, but oh my gosh, Christina Beeler has impacted my life in probably more than a crazy way that she realized. And I got to cry with her on Thursday when we were going over, but she was co-counsel in a case called Civility versus Cisneros here in Texas. It garnered so much fame nationwide because it was dubbed the Trump train case. And so I want to bring some people's memories back really quickly, but she will be showing you actual video evidence of what was portrayed. In 2020, the Biden-Harris campaign had sent buses to San Antonio, and they went from San Antonio along 35 with an ending point in Austin on our last day of early vote in 2020. And so it was going to be a really great caravan of it was just going to be interesting because we've never done it before in Texas, and things like this don't happen in the great red state of Texas. So when you were traveling on 35, and it's probably a highway that y'all are also used to up in Minneapolis, imagine getting swarmed by individuals with flags and almost feeling like your life literally is in danger because there are over 100 vehicles coming to just wreck on your parade. It was a wild experience to see and to also be part of. My family and I were part of the tail end of it, not as those individuals that swarmed, but we were just citizens just trying to get from one end of San Antonio to the other. And it was terrifying to say the least, but I can't even imagine what was going on in the minds of then Senator Wendy Davis and her campaign staffer, the bus driver, and a volunteer. So we have Christina Beeler, who was co-counsel for the case, and she is going to be also updating us on items that are occurring throughout, just overall how freedom of speech has been enacted throughout our practices, and then also what we see on the burner. And then we also have Dr. Amanda Gonzalez. She will be speaking on specifically social media and the impacts of us acting as civil individuals on social media, because so much of what we do and so much of what Christina will be talking about occurred thanks to social media. And so I always like to say, whenever people suggest that we've never been more polarized, I know Professor Futh has heard me say this. I actually say we always have been. It's just now people have a place to congregate and be together. And so it was always there. It just wasn't highlighted. So with no further ado, I'm going to hand it over to Christina.
Thank you. Let me share my screen. And while I am sharing my screen, I will not see y'all. So if you raise a hand or want to say something, like just jump in if you have a question or something. So let me share this. It should, give me 1 second. Here we go. Okay, do y'all see my PowerPoint?
Yes.
Okay. Let me, sorry, I'm not used to presenting on Zoom like this. Let me play. Do y'all still see it? Yes. Okay. Okay, great. So thank you, Melanie, for the introduction. As Melanie said, my name's Christina Beeler. I'm a senior staff attorney. I'm a senior supervising attorney at the Texas Civil Rights Project. And I'm going to present for you tonight on civility and decline, combating voter intimidation and political violence through the KKK Act. And also I'm going to talk about the First Amendment some as well, because that is something that has come up in some KKK Act cases recently. So I work at Texas Civil Rights Project. The Texas Civil Rights Project is a nonpartisan, nonprofit organization working here in Texas on civil rights issues. We envision a Texas where all communities thrive with dignity and justice and without fear. And just to give you a brief outline of what I'm going to present on tonight, I'm going to talk about the KKK Act generally as a tool against voter intimidation, and a little bit about the history of the KKK Act. I think it's really interesting. I think it's important in litigating these cases to keep the history in mind. And then I'm going to talk about the case that Melanie was talking about, and such a small world that she was on the road that day. I have spent literal years of my life focused on this day. And when Melanie reached out about doing this presentation, and then I talked to her and realized she was on the road that day, like it caused like a Slack storm between me and all my coworkers that somebody has asked us to present on this, and she was there. So what a small world. So I'll talk a lot about the Trump train case. Then I'll talk about some other modern era KKK Act cases, including Charlottesville and a robocall case in New York. And then I'll talk a bit about the First Amendment, because the First Amendment does come up in the context of these cases as a defense, usually. It is not an affirmative defense. I'll talk about that later. And an affirmative defense, of course, is like self-defense in a murder trial, where if you meet every element of your claim, you can still say this person is not liable or this person is not guilty because they have this other defense. It is not an affirmative defense, but it does come up in the context of these cases because, of course, some speech that we may not like as a society, or we may, depending on where you sit on the spectrum, on the political spectrum, you may not like that speech, but it may be protected. However, intimidation is not. But where is that line? So I'm going to talk about that a little bit. So let's go ahead and get started. The history of the KKK Act. So the KKK Act was passed by Congress and signed into law by Ulysses Grant on April 20th, 1871. It was adopted as a tool to allow the federal government to rein in very widespread violence against Black people in the South. It imposed both civil and criminal liability for a range of conduct, and allowed the president to suspend the writ of habeas corpus and impose martial law. And most notably, the thing that it's most known for is the creation of Section 1983. Section 1983 is, of course, litigated all the time, but the section that we're going to be talking about tonight, Section 1985(3) and Section 1986, those sections are less often litigated. So when you hear about 1983, it was actually part of the KKK Act as well, but I'm going to be talking about these provisions that are less litigated in the modern era. And these are the sections of the KKK Act. I'm not going to talk too in depth about this, but just very briefly talk about Section 1 is now codified at Section 1983, probably the single most important statutory provision in American civil rights law, allows individuals to sue in federal court when state and local officials violate federal law. Section 2 banned a host of private conspiracies, including insurrection, witness intimidation, and political intimidation. Sections 3 through 4 gave the president power to call in the military to address local rebellions and to suspend the writ of habeas corpus. Section 5 allowed federal judges to keep Klan conspirators off juries. And Section 6, now codified at Section 1986, which I'll talk about some today because we did litigate that in a companion case to the Cervini v. Cisneros case, requires everyone, public servants and private citizens alike, that knows about an illegal conspiracy banned by Section 2 and has the power to prevent it, to take action to prevent and minimize the effects of the conspiracy, and makes them liable in court for a negligent or intentional failure not to prevent it. So you've probably heard over the past 10 years a lot about cases about police failing to do something, and whether there's liability. And in a lot of situations, there's not. But under this section, under the KKK Act, there is this section that does allow you to hold people liable, including police, including like the city of San Marcos, which we'll talk about in the Trump train litigation, liable for failing to act when they know about a conspiracy, and they have the power to prevent it and they don't take action. So what does voter intimidation look like in 2024? So back in 1871, when this was passed, the KKK or other groups of white supremacists would show up at polling places or go to Black people's houses and tell them not to vote or tell them who to vote for, and would back up those demands with violence and threats, right? Like we have all heard stories or read about or heard about any other number of ways, stories from that time period after the Civil War, where Black people are literally being like pulled out of their houses and attacked for wanting to exercise the right to vote. So that is what it looked like then. Now it looks like this. So robocalls warning that vote by mail will lead to credit checks and mandatory vaccinations that were sent out to majority Black neighborhoods and majority Black communities. A caravan of Trump train vehicles surrounding campaign buses and driving aggressively, slowing traffic, causing traffic hazards, terrifying the people on the bus, which is what happened on October 30th, 2020. So it does look different, but the law still prohibits voter intimidation. Okay, so Section 1983, which is the section that we brought Cervini v. Cisneros under. In addition, we also brought state law claims, but this is the one I'm going to focus on tonight. Prohibits conspiracies to interfere with civil rights. So I put the language here so that y'all can see it. If two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such support or advocacy, if one or more persons engage therein, do or cause to be done any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. So that is a very wordy section, obviously, but I did, since it is an audience of law students, I did want to actually include the statutory language for y'all to see. And I'm happy to share slides after this presentation as well. But in sum, Section 1985(3) makes it unlawful to conspire to intimidate, threaten, or injure a qualified voter for providing support or advocacy in a federal election. Who can bring suit? So the supporter advocacy clause of 1985(3) includes a private right of action. So individuals can bring suit instead of having to rely on the federal government to bring suit. If you are an election law junkie or nerd, you may have heard about the Eighth Circuit's decision recently holding that Section 2 of the VRA, for example, doesn't include a private right of action. That is a contrast to this. So this is one of the primary reasons this statute is so important. For statutes that require federal government action, whether or not the statute will be a valuable tool depends on political considerations of the executive branch and who's in power at that time, right? So you don't know what will actually happen. It just depends on who is in office if the government has to bring these cases. But if there's a private right of action, then individuals can bring suit. So the Eighth Circuit recently held that Section 2 doesn't include a private right of action, even though people have been litigating Section 2 vote dilution cases for a very long time at this point, for decades. And there's all this precedent on it of cases brought by individual plaintiffs. The Eighth Circuit has now upended that, at least there. And we'll see if other circuits follow. But in contrast, 1985-3 allows a private right of action. Okay. What types of remedies are available? So unlike other statutes used to combat voter intimidation, Section 1985-3 allows for compensatory and punitive damages. Underlying compensatory damages not to compensate people for injuries, are not necessary to get punitive damages, which are damages to send a message to a defendant about their bad behavior. Being able to get damages makes it easier to bring suit. Voting rights litigation is expensive. Punitive damages are not dependent on compensatory damages. So even without compensatory damages, you could get punitive damages. But the fact that you can get damages under this statute is really important. In contrast, there are other voter intimidation statutes. The Voting Rights Act Section 11B does not allow for damages. It only allows for injunctive relief or declaratory relief. But in contrast here, you can actually get damages. So that is really important in making sure that lawyers will take these cases, right? Because then you can get damages and recoup some costs, and recouping costs actually is a bit separate, but you can get damages for your plaintiffs. And then this statute also allows for attorney's fees. Well, I jumped ahead a little bit. And I don't know if someone can tell me, are y'all seeing just the slide, or are you seeing my notes?
I think you're in presenter view, so we haven't seen many notes, but we can see both the present and the next slide.
Okay. Okay.
With note sections, so.
With the note section?
Yeah, on a couple of them.
Okay, cool. Well, maybe I should come out of that so y'all can see the slides better. Can y'all see the slides well?
We can see them, but it would be best if you,
Yeah, let me see. Hold on a second, because it just occurred to me as I was doing this, like, can they see these slides? Let me see if I can change it. Okay. Give me 1 second.
I thought if you went to slideshow, you just went to slideshow.
Yeah, play from current slide. It's still in presenter mode.
Yeah.
Maybe I'll just make it. Is that better?
Yeah.
Okay.
And then I have a quick question. Can we interrupt? Yeah. Can you go back to slide 8 really quick? When you were going over the statutes, that one, you said that one is no longer, that private action is no longer applicable?
Yes. It only in the Eighth Circuit.
Okay. Okay. Interesting.
So like even the Fifth Circuit hasn't yet held this. There are people who think it is coming, but only in the Eighth Circuit currently, to my knowledge. But if anyone has different information, I know for sure the Eighth Circuit, but if any other courts have held this, let me know, but I don't think so.
I think so many of us are going to be using our free Westlaw and Lexis while we still have it, so.
I still just get on Westlaw to research things, even on cases that I'm not working on. So I understand. So in contrast, I already kind of talked about this, VRA section 11B, another tool used by voting rights advocates, makes it unlawful to intimidate, threaten, or coerce, but does not allow the possibility of damages, which makes these cases harder to bring. Is a showing of racial animus or other class-based animus required? So maybe by a show of emojis, let's say thumbs up and thumbs down, what would your guess be? Yes, do you think a showing of racial animus or other class-based animus is required? Or no, you think you don't need animus or showing that of essentially like bad faith connected to race or another protected class?
Here, we can do like, because we can do thumbs up for yes, and then we could do the surprise face. So like surprise face for no.
I see a hand up. Leanne, did you have a question?
No. I was just doing up because that's what Melanie said. So unless I misunderstood her. I meant to do a thumbs up. Sorry about that.
Okay, I see a few emojis. So the answer is no. A showing of racial animus or other class-based animus is not required under 1985-3. And that is useful for plaintiffs, right? Because showing racial animus is actually very difficult. That's very hard to prove. You in many cases need some kind of smoking gun, right? It's hard to show animus in this way, and under this statute it is not required. So that is something useful for voting rights advocates. And section 1986, this is the section I was talking about earlier, makes it unlawful for a person with the power to prevent or aid in preventing voter intimidation to neglect or refuse to do so. It also includes a private right of action, and it allows for damages, which again, helps make sure that people take these cases, and make sure that we are not subject to to just seeing what happens with these cases depending on who is in office, right? So we don't have to wait for the DOJ to bring these cases. Individuals can bring them. Okay, so I'm going to show a video just briefly talking about the Trump train case, because I thought it did a decent job explaining some things in it. So let's try this and see if
civil trial involving
it works. Let's see. Do y'all see the YouTube link or the YouTube video? No?
Mm-mm.
Okay. Wow. All my tech issues. Okay, I may have to cut videos that are not embedded if we have any issues.
I wonder if you get out of presentation mode or anything like, and you pull back. Or is it going to a different window whenever
It's going
you?
to a different window, but I can share that window with you on.
Yeah, share that window.
Yeah.
That'll help.
Okay. I don't know if I'm going to be able to switch windows. I might not. It is giving me some difficulty here. So I'll just talk about it. And I can send these links afterwards. But yeah, that's unfortunate. All right. Can y'all still see the slides?
We can, but you need to zoom in now.
Okay, let me go back. Okay. So for the Trump train case, I will talk about it, and some of the videos are embedded in these slides. So let's just start with one of those. This is part of what happened on October 30th, 2020.
Riding them out of Texas. It is hilarious. I'm about to run out of gas, which I'm sure some of you would love. Shit, look at that.
All right, so as you can see, I mean, it may be kind of hard to see on your screens, but on October 30th, 2020, this is part of what happened that day, but I'll back up and tell a little bit more about it. The Biden-Harris campaign bus and the Biden-Harris campaign were campaigning throughout the Hill Country and throughout Central Texas. They started in San Antonio that day on October 30th. They had several days of campaigning in Texas. This was the last day of campaigning that was planned in Texas. They started in San Antonio, and they had many protesters there. There were people who were screaming and shouting, but people were just screaming and shouting. They weren't like behaving in a way that was especially concerning in the way that happened later on. But when the Biden-Harris campaign left San Antonio, there were 3 people on the bus. Wendy Davis, a former Texas state senator, David Gens, who was working for the Biden-Harris campaign in Texas, and Timothy Holloway, who was a bus driver who was just trying to do his job that day. He was not working, I mean, he was working for the campaign, right? He's just driving the bus, but he was not affiliated with the campaign. He was just working for the campaign as a contracted bus driver. So they started driving from San Antonio to what was planned for the next stop. They were going to stop in San Marcos at Texas State University for a voting event, for a campaign event. They were going to shake hands, hand out campaign paraphernalia. They were going to talk to students at Texas State, but they never made it there. Because when they got onto I-35, and if you're not from Texas, it's one of our primary interstates, and it runs through other states besides Texas. And when they got onto I-35, they were being followed by some of the Trump trained folks who had been at the event. But people were mostly driving normally, but then more and more Trump trained vehicles joined. And how you could identify them is that they had flags, they had signs, they were sticking fingers out of windows. You can guess which finger. They were screaming, they were shouting. And so as they were driving from San Antonio to San Marcos, more and more and more people joined. When they passed this one exit called Solms exit, then a ton of people joined. So there were people waiting on the overpass. There were people waiting on the shoulders of the road. And at some points of this, there were 50 to 75 Trump train vehicles surrounding the bus. And you can imagine if you're on this bus, this campaign bus, and you have to remember the time period that we're in, right? Like in 2020, this is not long after Donald Trump said after Charlottesville that there were fine people on both sides. And at this time, there was a lot going on. There were a lot of tensions related to COVID and masking, especially in Texas, and mask mandates. And so the people on the bus were very, very terrified as this was occurring. They had no idea what these people were going to do. They had no idea what they wanted. And they were really surrounding them. They had people in front, people on the side, and people behind them. So they were truly surrounded. They were concerned about getting off the interstate because if they get off the interstate, right, one of our plaintiffs, the bus driver, testified to this at trial. He would have been worried that these vehicles would have gone with him. And then if he ends up stuck at a red light, what's going to happen, right? And as they are driving, they go through New Braunfels. The police, they called the police. In New Braunfels, the police responded. They came out. When the police came, people were driving less crazily. People were not engaging so aggressively. But then when the police dropped off, which they did at the city limits of each city, or the county limits, depending on who was responding, and after the police dropped off, when they went into San Marcos, that is when the behavior really escalated. And as they were in San Marcos, they were calling 911. The people on the bus were calling over and over and over again. The police would not respond. And we later got access to contemporaneous 911 calls where the police were really making fun of the people on the bus and saying they just need to like drive defensively. And essentially saying that they weren't going to respond. That's not a direct quote, but essentially saying like, you know, they just need to deal with it. And so the police didn't respond in San Marcos, which is when the behavior really escalated, because there were no police around. And so the incident that you just saw before I was talking is video footage of the black truck was one of the defendants. His name is Elizar Cisneros. He was driving that black truck, and the white vehicle that he hit was being driven by a Biden-Harris staffer who was a college kid in his early 20s who just wanted to volunteer with the campaign and was just excited to be a part of the campaign. And what you don't see in this video is that the black truck purposefully came up this lane over here next to the white vehicle. You can see in the video footage that the white vehicle is sort of straddling more than one lane, but at this point they've been surrounded for quite some time. They're quite scared by this point. And again, this is a college kid. If you know anyone that's like 21, like when I was 21, I have no idea what I would have done if this happened. He was trying to stick with the bus, and he was freaked out about what was going to happen. This black truck saw this white staffer here, figured out that he was with the bus, and he zoomed up into this lane to get next to the bus and to get next to the white staffer. And then he did what one of our expert witnesses called a pit maneuver, which means he like took his vehicle and he swerved into this white truck to push it. And that is what he did. He pushed it, and he hit it. And should you have any doubts as to what he meant to do, the person who hit the person in the black truck, Elizar Cisneros, he went on social media later that night, or yeah, it was later that night, and said in writing about this incident, quote, and sorry for the language ahead of time, quote, "I slammed that fucker." So should you have any doubt about what his motivations were, well, he said what they were, and said it in writing. So that is one thing that happened that day. And then I'm going to show a bit more footage. The people in this white truck over to the left of the screen, there were 3 people in this truck. 2 of them were defendants in this litigation, and they settled ahead of trial. So the driver and the woman in the passenger seat were both defendants, and they settled. And I will play this footage to give you an idea of some other types of things that were going on around the bus.
Look at that crack right there. Look at that crack. That's crack. Right there. Surrounded. They're surrounding this dude. Got that? Got this piece of crap right here. Crap. Round of the butt.
All right, so you could hear them saying they were surrounding the bus. There was evidence at trial, as Melanie talked about earlier. There was evidence at trial of some of the defendants' social media posts. They had posted things online afterwards and during, saying that they were going to surround the bus. Not every defendant, obviously, the evidence against every defendant was different, as is in most conspiracy cases, right? But They had posted saying they were surrounding the bus. There was one defendant in particular, one of the ones in that white truck, who posted hashtag Operation Block the Bus, right? Which gets at their intent, that they intended to block this bus. But I did want to note a few things about our jury instructions, because these are things that I've gotten questions on the most commonly when I've talked about this case. So one, for a conspiracy case like this one, you are not required to show that the defendants actually knew each other to prove conspiracy. And one way to think about this is to think about, I'm sure many people on this call have seen like those mobs that go into stores and break in, and they like take a bunch of stuff from these stores, and they're all wearing masks, and it's hard to figure out who knows who. And maybe they don't all know each other, right? Like maybe someone's just walking by on the street and they decide, oh, like, look at this, I'm gonna join. Well, now they're part of the conspiracy too. You actually do not have to all know each other. They don't have to be friends. They don't have to have text messages to each other. That's a common, I think, misunderstanding about conspiracy law. You're not required to prove that these defendants, so we brought suit against 6 defendants, or at least those were the ones that were left at trial. There were 8 defendants. But there were other people involved in this. There were temp tags that were used by some of the drivers on October 30th, 2020. And some of those temp tags were not real temp tags. And so we couldn't track down everyone connected to this case. So you're not required to prove that the 6 people we brought, or the 8 people, but 6 by trial, that we brought suit against conspired with each other. Just that they conspired with someone, even if they're not a defendant in this case. And it does require a showing of intent. So a violation of the KK Act supporter advocacy provision, you have to prove that defendants had the intent to prevent plaintiff supporter advocacy by force, intimidation, or threat, sorry about the typo, or to injure them on account of such support or advocacy. So the intent showing that is a high bar. Let me pass these. We already watched this. Before I talk about the trial, I want to talk about what happened beforehand. So in our companion case, which I've kind of alluded to already, Civility v. Stapp, which is the case we brought against the city of San Marcos for failing to respond, along with several other named police officers. We settled for $175,000 plus training for all SMPD staff and officers regarding election violence and intimidation. And they provided a statement taking responsibility for their failure to respond to repeated 911 calls on that day. They said that their actions on October 30th, 2020 did not meet their own standards. All settlement proceeds were split between the 4 plaintiffs. There were 4 plaintiffs at the time. Eric Cervini, one of the plaintiffs in this case originally, had left the litigation by the time we went to trial for personal reasons. And so that case had settled. And then in Davis v. Cisneros, it is now Davis v. Cisneros. It was Cervini v. Cisneros. In Davis v. Cisneros, which is the case that we've been talking about, we settled with 2 defendants, the driver in the previous video, Kyle Kruger, and his girlfriend, Hannah Say, who was the daughter of 2 other defendants at trial. So 2 other defendants at trial are her parents. And then we got a thoughtful, expansive order on a motion for summary judgment that we plan to fight to protect. It is a very important order outlining the contours of the KKK Act and the supporter advocacy provision. So that order is really important and is really thorough and deals with some of the First Amendment arguments and I'll talk about those later, but I did want to note that. And here were the issues at trial against the remaining 6 defendants. We had our KKK Act supporter advocacy clause claim. We had state law conspiracy, state law assault as to 2 particular defendants, state law aiding and abetting assault. And this was the result at trial. The jury found liability as to the ringleader for a KKK Act violation, but not for the other 5 defendants. And there was no liability found on any of the state law claims. The result was $10,000 in damages as to Timothy Holloway, the bus driver, and $30,000 in punitive damages. And you'll recall that I talked about punitive damages earlier. Punitive damages are to send a message, to say to a bad actor, hey, this was really bad and you shouldn't do this, and we're going to impose liability on you for how bad this was, to try and deter this kind of behavior. So punitive damages are a bit unique, unlike the compensatory damages, which are just meant to compensate for injuries. So we had more in punitive damages than compensatory damages. And the injuries at trial, I realize I haven't talked about those as much. The plaintiff's injuries, so Miss Davis, Mr. Gens, Mr. Holloway, their injuries were emotional injuries, so emotional distress. Miss Davis started having like severe anxiety when she was speaking in public, even though she'd been in public life for decades, and hired private security for the first time. Mr. Gens was feeling very depressed and had trouble getting out of bed. Mr. Holloway started taking sleep medication for the first time. He started talking about, he talked about at trial how he really felt like the captain of the ship and the pilot of the plane. And he was so anxious as this was happening. And then afterwards, because he really was worried, like, how am I going to get these people to where they're supposed to be? And can I keep them safe? And if we get run off the road, like, what am I going to do? There are 3 of us and there's 50 or 75 of them. And they're clearly not here to like shake hands with us, right? Because they're screaming at them. You heard in that video, they're screaming pedophile. Joe Biden's a pedophile. They're screaming 4 more years. They're screaming at them. So that those were the injuries that the plaintiffs endured, and they sought damages for. So I want to pause before I go to other modern era KKK Act cases, and ask if there are any questions so far about the Trump train. I am going to talk about the First Amendment stuff, but I'm going to talk about it in the context of all the modern era KKK Act cases that I'm going to highlight tonight. So I want to pause and see if there are any questions. Okay, so I'll go ahead. And I did look up very quickly how to stop share and restart share while y'all were watching one of the videos. So I'm going to do that now and actually play this video. So, well, tonight, give me 1 second to get over to that video. I'm a bit of a Luddite. I still like use vinyl records, so. Okay. Now share screen. Here we go. If you cannot hear, like raise a hand and let me know. I'll be looking over here because I have another monitor.
Jury has been selected in a trial that will once again focus the nation's attention on the 2017 Unite the Right rally in Charlottesville, Virginia. The jury will decide whether the organizers should be held accountable for the violence that turned deadly. CBS's Jeff Pegues is there.
Today in court, the jurors were sworn in as some of the defendants, self-proclaimed neo-Nazis and white nationalists, looked on. During the Unite the Right rally in 2017, white nationalists marched through the streets. They carried torches and clashed with counter-protesters until a car driven by neo-Nazi James Fields plowed into a crowd, killing Heather Heyer.
The goal of this lawsuit, first and foremost, is justice for our plaintiffs and accountability for those responsible for the violence 4 years ago.
Amy Spitalnik is the executive director of Integrity First for America, which brought the lawsuit on behalf of some of the victims of the violence.
The facts are clear. This was a conspiracy motivated by racism.
The plaintiffs believe that they will prove their case by highlighting social media chats and text messages.
I think ultimately Charlottesville was good for our movement, but
among the defendants, Richard Spencer, who was one of the rally organizers, will claim that there was no conspiracy and they had a First Amendment right to protest. But messages between Spencer and rally organizer and defendant Jason Kessler reveal this exchange. We're raising an army, my liege. for free speech, but the cracking of skulls if it comes to it. The violence that day haunts Liz's signs.
I heard screams. I heard this awful sound.
One of the plaintiffs who narrowly escaped injury when the car hit Heather Heyer.
I don't think I will ever not be scared.
Her name is on the court docket. Signs B. Kessler. The plaintiffs are going to use something called the Ku Klux Klan Act, which was put on the books in the late 1800s to combat attacks on African Americans. Laura.
Hard to believe. Jeff Begaze, thank you. Well, tonight a jury's been.
Okay, and while we are watching these videos, that way I don't have to stop in a minute. I'm gonna go ahead and play this other one as well. One second. Okay, well, apparently it's gonna play a commercial for a second, but.
New York State Attorney General has.
Okay, let me share my screen. This is about the next case that I'm going to talk about, another modern era KKK Act case. This is called National Coalition on Black Civic Participation v. Wohl, and was brought in New York. And I am going to share my screen.
Reached an agreement in the case of two conspiracy theorists. The New York State Attorney General has reached an agreement in the case of two conspiracy theorists who intimidated Black voters ahead of the 2020 election. Under the agreement, Jacob Wohl and Jack Berkman will pay up to $1.25 million for their wrongdoing. Last year, a federal judge found Wohl and Berkman liable for targeting Black voters with threatening robocalls and disinformation in an attempt to discourage them from voting. The AG's office said the robocalls reached as many as 5,500 New Yorkers. Well,
Okay, so now let me go back to PowerPoint. And get out of presenter mode. Okay. All right, here we go. Okay, so the Charlottesville case was also a KKK Act case dealing not with voter intimidation, but with political violence. So among other claims, a KKK Act 1985-3 case, but a different provision of 1985-3. So if you after this this Zoom, if you go look up 1985-3 and read the statute, if you go, there's 3 sections of 1985. And the third one has the supporter advocacy provision in it, but it also has an equal protection section in it. So this case was brought under the equal protection section. And in this case, the jury awarded more than $26 million for state law claims, but deadlocked on the KKK Act claims. Virginia has a statute limiting punitive damages, the damages we've been talking about meant to send a message as to the defendant's bad conduct. So a court lowered the award, but even after appeal, total damages were over $9 million. And then in this National Coalition on Black Civic Participation v. Wohl, this case was a VRA Section 11B and 1985-3 case supporter advocacy clause provision. 2 conspiracy theorists used robocalls to intimidate Black New Yorkers from voting by mail in the 2020 election. And I'm going to actually read you the robocall message that went out. Hi, this is Tamika Taylor from Project 1599, the civil rights organization founded by Jack Berkman and Jacob Wohl. Mail-in voting sounds great, but did you know that if you vote by mail, your personal information will be part of a public database that will be used by police departments to track down old warrants and be used by credit card companies to collect outstanding debts? The CDC is even pushing to use records for mail-in voting to track people for mandatory vaccines. Don't be finessed into giving your private information to the man. Stay safe and be aware of vote by mail. So the court found that there were fact issues such that a motion to dismiss was not appropriate in this case. This case ended in a consent decree and $1.25 million for both the plaintiffs and the New York Attorney General's office to dispersed among victims of this incident. And what do all of these cases have in common? So one, there's an element of intimidation, right? There's either violence being used to intimidate people or threats or intimidation being used to intimidate people. The defendants in all of these cases also made First Amendment arguments. So where does the First Amendment stop and give way to your right to go out into the world and support and advocate for a candidate? And each of these cases addressed that issue. So the First Amendment does not provide cover for political violence, threats, or intimidation, but it is both an issue of fact and law. So there are some questions for a judge to decide. I'm not going to get too in the weeds. There's some questions for a judge to decide and some questions for a jury or the fact finder. So if you decide not to have a jury for some reason and the judge is acting as the fact finder, the fact finder and the judge will have things to weigh in on these First Amendment cases, or on the First Amendment issues in these cases. In Wohl, which is the robocall case, the court said, and I went ahead and like copied and pasted the language because I didn't want to mess up any of this. I want to make sure that you see the exact language. Defendants contend that the expression their robocalls communicated constitutes speech protected by the First Amendment. Defendants' theory implicates a fundamental threat to democracy. The First Amendment cannot confer on anyone a license to inflict purposeful harm on democratic society or offer refuge for wrongdoers seeking to undermine bedrock constitutional principles, nor can it serve as a weapon they wield to bring about our democracy's self-destruction. This is really strong language and really helpful for civil rights advocates, right? That the First Amendment does have a line. Just as you cannot go into a crowded theater and shout fire, you cannot do this. So the conspiracy theorists that sent out these calls, well, the First Amendment does not protect that. You do not have a First Amendment right to use robocalls to intimidate people from voting. In Sines, which is the Charlottesville case, the court said the First Amendment does not shield defendants from allegations of violence, noting that the First Amendment does not protect violence, but this case had a bit more nuance, right? So the court also noted that the First Amendment does require a careful parsing of the allegations, whereas here some of the defendants' behavior certainly was protected by the First Amendment, right? Marching and screaming terribly offensive, horrific, racist things, or anti-Semitic, that is not something that the law prevents. I should say that differently. You have a First Amendment right to stand out where you are allowed to be in a public space. In most, I'm not going to go deep into the First Amendment analysis there, but you are allowed to stand out and yell really offensive things. But some of the conduct that happened at Charlottesville, of course, was not protected. Picketing and marching, even if motivated by racist ideology, would be protected speech. But forming a conspiracy to commit violence is, of course, not protected by the First Amendment. And then the First Amendment in the Trump train case. Defendants argued in the Trump train case that the First Amendment was an affirmative defense, meaning if plaintiffs met all the elements of their claims, the First Amendment would protect them, like self-defense in a murder trial. The court rejected that outright. And in the summary judgment opinion, made it very clear that the First Amendment is not an affirmative defense. So regardless of what the jury actually found, right, because the jury was the fact finder, even though 5 of the defendants were found not liable and just 1 was found liable, the one that was the ringleader, though that does not negate that summary judgment order. So this is important because as we go into the next election cycle, the one that we're in now, early voting in Texas started today. This is a useful tool. The KKK Act 1985-3 is a useful tool to combat voter intimidation. And the court in the summary judgment order said the First Amendment does not protect veering cars at a bus, unlawfully obstructing a public highway, or creating traffic hazards, nor does it extend to assaults. Driving alone, never mind reckless and dangerous driving, is not an inherently expressive activity in this context, just as the First Amendment does not protect a driver waving a political flag from running a red light. It does not protect defendants from allegedly threatening plaintiffs with reckless driving. So even if a jury found that even though a jury found as to some of the defendants that we could not, a jury did not side with us on some of our allegations, even though of course we disagree with the jury's finding, that doesn't change this law, the law that the summary judgment order shows. So this piece, this one sentence, just as the First Amendment doesn't protect a driver waving a political flag from running a red light, that is the one that I always come back to when I'm explaining this to people, that if you're running a red light, but you're screaming out your support for a candidate, that is not protected. That is not protected First Amendment speech. So that is the line. It is very tricky. There's lots of nuance. There's lots more than this. You could teach a whole semester on the line between First Amendment and supporter advocacy of a candidate. But I'm sorry, between liability for intimidation or threats based on supporter advocacy of a candidate. You could teach a whole class on that. But I did want to cover this briefly and just say there is a line, and the line is if you are engaging in violence or intimidation, which sometimes can be hard to see, but if it is conduct that is meant to intimidate people, that is not First Amendment activity. So that is it for me. And I will turn it back over to Melanie. Thank you so much for inviting me tonight.
Oh my gosh, thank you so much, Christina. We've got some claps. If y'all have any questions for her, please either drop them in the chat or you can just come off of mute if you're available. But I do know that some people have to drop off because it's getting a little late, dinner time, all that stuff. Okay. Christina, thank you so much. Thank you. Thank you. Yes, her email is there. I will be sending it also out to everyone that has participated. And thank you so much. Happy Election Day. I hope it's quiet for you, but unfortunately, I don't think it will be. So, and I'll also be sending out information about how you can get involved in your local areas to volunteer even now as an election protection I think I forgot team. I know that that's what we call it here in Texas. So because you can currently help and assist out as a law student, well, depending on your jurisdiction, actually. So I should have said that. Okay, thank you so much, Christina. And next up, we have how to apply it to our everyday journeys, and as law students who will now also be dealing with going through the bar exam preparation and having our character and fitness be examined. It's going to be very vital that we maintain civility and decorum online. So with that, I'm going to be going over to Dr. Amanda Gonzalez.
Hi, everyone. Can everyone hear me? Is this fine? Okay. Let me see. I also have, I'm the person that always gets the presenter mode mixed up. Let me, okay. This. Can y'all see that? Is that clear?
Yep, looks great.
Okay, okay. Well, again, thank you so much. My name is Amanda Gonzalez, and so my presentation is on how we make sense of social media platforms and its future implications on society. So I really enjoyed actually the last couple of presentations because it is so interesting. I am here in Texas, and I know there's a couple of fellow Texans on here. So we kicked off early voting. And here in the county that I'm currently in, we've seen some record numbers finally in the general election in comparison to the primary. So if you have early voting in your area, please get out and vote. Again, today's discussion, I know that I am probably the one thing keeping you from the dinner table. So I'm gonna just make this short and sweet. But just today, I just wanted to briefly go over who I am, the goals of what I hope to accomplish in the presentation, how I'm applying the theory of sense making, and I'll go into that a little bit more. Sense making in social media. I know we've been talking a lot about the different posts and just different things that have been happening online that we've seen. And I know a lot of us have seen a lot of different posts depending on geographically who's running in your area. I have an interactive activity just to make sure you're still awake, and just questions and the end of the presentation. So I'll just keep going. Okay, so about me, I actually recently got my my doctorate last May, and so I truly love education and I do love politics. One thing that I was really excited about this presentation and the ability to present was it kind of hit close to home when it came to the types of advertisements that you can put online. I actually ran for public office, and so I too had to go through that process of trying to get advertisements online and seeing what was appropriate and what met the standards for different social media outlets. My research interests are education, politics, and governance. So again, just really quickly, the goals for today is just understanding what some of my research has concluded, having a thoughtful discussion, and then of course, future collaboration. I know y'all are in law school, but I also understand that research is very important. And so as I continue to be an independent researcher, I always look for new ideas or the opportunity to collaborate in the future. So I'm going to talk about sense making, and really sense making is exactly what it sounds. It's about making sense. So it's actually a theory from Carl Week, and he talks about how sense making, it focuses on how people generate what they interpret. There's different sense making. There's sense making individually and then collectively. So collectively, what sense making is you are, if you're thinking about it as online terms, is simply putting an online audience in a community, so an online presence. So those online groups that you're part of, whether it's the garage sales or the different type of groups that they have online, we use these type of groups, and we actually, as an audience, as users, we undergo collective sense making, because collectively we make sense of how groups of individuals that are in those groups, how they come together and make sense of a post. And so social media, we know we've used it to help us make announcements. It helps us drive marketing outreach. I apologize if you can hear my dog barking in the back. And it helps distribute information. But nowadays, you can look at the type of content. You can be very intentional about the type of content that you're putting out. And so that comes with different advertisements and different posts that, you know, what type of audience and what type of feeling you're trying to capture. So with sense making, and especially online with social media, there is public participation. So in my research, when I was actually doing my dissertation, and based on sense making, more in the lens of COVID school reopenings and the measures that were put in place, because here in Texas, it was a little different. There was big mismanagement. I think there should have been more local control in how we reopened our public schools. At a time, schools were given control to open, And then the governor came and demanded schools open in the fashion he wanted to, which was as quick as possible, but not as safe as possible. And so in my research, when I was looking at public participation in sense making, so I had reviewed a case study, and it was a case study from the Netherlands. And so what they did was they had wanted to see where citizens were when it came to reopening the area. And I talk about this case study because it really described the role of public participation in the decision-making process. And that's the same thing when it comes to voting, as Texas kicked off the first day of early voting. And so 30,000 Dutch citizens, they were asked to recommend which lockdown measures that they wanted to be relaxed during COVID, so that the government could solicit this input and then, of course, improve the quality of the government decisions through this participatory practice. And so depending on the feedback or the click rate, nowadays, especially on social media, you can track how a social media post, how it resonates with an online community. So like I said, early voting has started in Texas, and there is like 1 million paid advertisements for local candidates. Everybody right now is trying to get out their message of why they're a better choice for this upcoming general election and why they should be given more consideration. I want to go into a little bit more about sense making. So again, like I've mentioned, sense making is taking the first step of asking yourself what is happening, and the second of what you will do next. So if you think about it, it helps individuals and organizations evaluate situations, and it involves an ongoing retrospection of images to rationalize what we're seeing and what we're going through. So when I go back to Carl Week and his theory of implementation, it's his theory and talks more about implementation agents. And so users like ourselves are what he would note as an implementation agent, because you're using your interactions online and you are letting them either influence your knowledge, your belief sets, and maybe your attitudes. So as you know, right now, many people regard social media outlets like TikTok as a credible news source. A lot of people tend to get their news from there. But now you're seeing a lot of that social media presence of being that deliverer of breaking news or of different announcements that are wanting to be made. So it's really quite interesting in how it allows you to see how you develop your own opinions and views. So sense making and social media. And so I know that this legislative forum was really based on the court cases of the Net Choice versus Paxson and Moody versus Net Choice. And it's kind of interesting in what I saw, because you had both the state of Texas and Florida, and they felt that their posts have been censored online, and that these social media outlets have some bias against more of the conservative governmental entities. So, of course, Texas and Florida are primarily conservative, and both of their legislative bodies, both the House and the Senate, are Republican dominated. So while they were governmental entities, of course, the courts had ruled that, there's no, they're not subject to the constitutional requirements of freedom of speech, because social media was more of a private enterprise. And so when I looked at censoring content and what it could do, censoring content and the claim that they were making, it actually, when we have any sort of censorship, it can disable an individual or a collective audience's sense-making process. Because when we have censored content, it's not authentic, since it has to meet the requirements of a social media platform in order to be posted. However, the requirements are not as stringent as both Florida and the Attorney General of Texas had made it sound. Some of the requirements, as a person who actually has gone through the process of putting together advertisements, is, of course, you don't want to incite violence, you don't want to encourage criminal activity, but you can use these platforms as a way to educate individuals on the subject matter. And so I actually put the picture, and again, I know that there may be people on both sides of the aisle, but what you'll see here is a post from Vice President Kamala Harris, and it has like a comparison piece where you have Harris and Walz, and then you have the Trump-Vance agenda. And you'll see on here that she's comparing both their political agendas and saying how the Trump political agenda is a direct attack on our freedom and our future. But what you'll see again is on the right-hand side, and I made sure to try to include it, was actually the commentary. And that's a good example of sense making, because you do have people who are on both sides of the aisle giving more of their opinion, their belief set, engaging in sense making, and really showing where they fall on the topic of this comparison piece. And so again, we view social media as an online platform, and we use it to share personal news, career interests, activities, but mainly we have established some real connections, and we use it to gain knowledge of new things, to develop new interests, and of course to be entertained. Oops. Okay. So very quickly, I just wanted to do a really quick activity. Again, I know I'm the divider between being online and getting something to eat. But really quickly, I just wanted to have a quick activity. So I put a couple of posts on this slide, and I just wanted to get a sense of what are some of the thoughts that come up. So you can drop it in the chat. You can raise your hand or just chime in, but what are some of the thoughts that come to you when you see this slide? There's not a right or wrong answer. What is happening with the feet and poo? That's what I thought. And actually that is from healthcare.gov. So I think the post was maybe implying coverage for healthcare coverage for the Affordable Care Act. The candy makes me hungry. Makes me hungry too. If only I could bake. I'm not a baker. But this is actually just an example of what pops up in my sponsored ads. And so cute puppies, I think of targeted advertising. Yeah. So all of these are correct. The cute puppies is, you know, very, very correct. And again, I kind of put my dogs out there. I feel interested in the content, but gravitated to the font of one of the posts. So very quickly, what I did actually is I put together different paid advertisements that made it to my social media outlets. And what we've known is that social media has really gotten in tune with the things that interest us the most. So being a person who uses and has healthcare coverage through the Affordable Care Act, I know how important it is to have healthcare. And I'm so proud and so lucky to be able to have that. Being from San Antonio, Texas, again, it is always hot. We don't have winter here. I know it looks like I'm wearing a sweater, but I think it's just because it hit below 90 degrees. but it tells you more what the weather is. So the different posts, and then of course, Nissan. I don't know if the batteries was more to tell me that I needed more energy or just needed more batteries. But I also put my dogs on there because that is something that I love my animals, and so I love to feature them in most of the content that I actually post on social media. But what me asking you in this interactive activity was actually you making sense of pictures that I put in front of you. And so while, someone said there's targeted advertising, going back to my point is there is. So when you do advertisements in social media, it has gotten so smart in the target. And so one of the things you can do is you can target by gender, you can target by age group, and you can target by zip code. And so, when you're looking at the content that you're posting, you can be very specific and very intentional in your messaging and what you're trying, the point of view you're trying to come across, or in this case, in a theoretical sense, what type of sense you want people to have on a cause or a person. And so just wanted to kind of give that example, just so you could see what sense making was. Go to the next slide. And then very quickly, so one of the things that I just wanted to make the point of is that, when it came to making sure that we are keeping things safe online, that we are being very mindful of what type of reactions things of posts and being on these different social media outlets, it's incredibly important that we understand that as individuals, we individually make sense of things differently. And while there is parameters of what you can and cannot post, having censorship or having these parameters, of course, do kind of restrict an individual's way of making sense of things, because when you go back, it's not authentic of what you were truly going to put before. But in some content, and especially in some of the content that I've seen online, especially now with politics and voting and things coming on, you need those parameters to make sure that the content we're putting out doesn't incite violence or encourage criminal activity. And so, I wanted to open it up. Again, I made my presentation really brief, but wanted to see if anybody had any questions or comments. And again, I'm so sorry I don't know if you hear my dogs, so I'm so sorry about that. Anybody?
Well,
thank y'all. I really appreciate the opportunity, and I love, again, I don't know if y'all are a mix of 1 year, 2 years, 3 years.
We're a mix. Yeah, there's a big mix, and we also have some professors on here. So
awesome. Well, the best of luck. Like I said, I had graduated last May. And so I understand what it's like if you're working full time or part time and going to school and you have a family. I understand the commitment and the sacrifice. So just hang in there and know that at the end is the reward. But if y'all ever want to get a hold of me, if there's any questions or anything that I could answer, I put my email address on there. But again, Melanie, thank you for the opportunity to come on and present, and thank y'all and best of luck in y'all's future endeavors. So thank you.
Thank you, Amanda. And I will be sending out the contact information for our speakers tonight, as well as opportunities for you to be published in the Quadriga. So one of the other things that I do as policy editor is publish the Quadriga, which is the online blog where you can write about anything public policy related if it suits you. if you just have something that's on your mind, you just need to get off your chest, this is a great way to do it. And we publish monthly, anywhere between 2,500 to about 5,000 words. That's it. So that was my plug for the Quadriga. And for everybody that stuck with us, thank you all so much. Please do not forget, I'm actually gonna put it in the chat. I forgot to do it earlier. Sorry, y'all. That shows that I was like really engaged with everything. But I will be putting in the DEI credit. Oh no. There we go. I am so sorry. I should have had that prepared. I am so sorry. So as a reminder, the title will be Fall Legislative Forum. And there we go. And for the Journal of Public Policy, and you get 1.5 credit hours. I'll leave that up for a few seconds. I will go off camera. But thank y'all so much for attending. I'm so excited that it's over, but I will be stopped recording. There we go.